Subramanyam, Chairperson of HR, for opening your remarks and setting up the stage for us. We also appreciate your unwavering commitment for fostering connections to HR. Thank you, sir. A special thanks to our keynote speaker, Mr. Senthil Kumar, Regional PF Commissioner. Your comprehensive
of more than 10.5 lakh members. It's a very humongous task. Trust me, we handle this service, so we understand this fact. Consequent upon cancellation of UPF exemption of Team Lease, one of the large staffing companies in India. Ensuring seamless delivery to stakeholders active in social media and providing real-time information and solution assistance related to UPF services. During the tenure at RVCE Tambaram, Chennai was present and tenure on RO Bangalore Central. Many innovative practices have been initiated by him, particularly the hazard-free settlement process to claimants of deceased PF members was one such initiative, appreciated by many beneficiaries. A special mention about the measures undertaken has been appreciated in the regional committee meeting of the Karnataka. Zero tolerance against rule breakers to ensure full eligible payment is paid to claimants is one of the highlights of efficient monitoring. Nidhi Aapke Nikat 2.0 awareness sessions are personally conducted by him and in visiting bigger establishments for creating the awareness on a weekly basis and guide employees and employers in compliance and making EPF more closer to their hearts. This is what I would say. A very voracious reader of personal finance, investment in related books and biographies of political and business leaders. I welcome cordially Mr. Senthil Kumar to this session at BCIC today for presenting his views on Provident Fund Matters concerning both the employees and employee. I'm sure this would be a great enrichment to all of us present here and present online for understanding the whole of the PF matters. Welcome, sir. Thank you very much for coming today here. Appreciate that. I would request Saraswathi Kasturirangan, Partner Tax on Deloitte South Asia, to probably set a context of the whole session and begin. Saraswathi, over to you.
Thank you, Subbu. Thank you so much, sir, for being with us. I do feel privileged and humbled to be on the panel as you are. This is indeed a very complicated topic from a compliance perspective, but I know personally that the amount of steps that you've taken to make it simple and easier for people not only to approach you, but also to solve it instantaneously. So thank you so much for that. Thank you, BCIC, for giving me this opportunity. As a part of setting the context, basis what I discussed with Mrs. Senthil, what we thought was we would quickly give a very broad overview. I won't take more than 15 minutes. And then we would really get down into what are the topical subjects. I've listed out about 10 or so of what we think are things which are bugging the industry. And then I would pass it over to you, sir. And I know you would, in your usual style, you would have a lot of comments and answers for all those challenges. So I do look forward to that. But from a content perspective, I will quickly touch upon a very high level, 30,000 feet, if I can say, about what the fund and the scheme is all about. What are the compliances we need to look at? I will touch upon both of this, both from a domestic worker as well as from an international worker perspective. Quickly touch upon the non-compliances, consequences of non-compliances, and then we will dwell some time on the topical issues. So if we could go to the next slide, Preeti, the next one, please. So basically, why is the PF and the pension scheme, why are these very important? And how does it really impact the people who are invested in this, if I could use the word? So the Employee Provident Fund is a defined contribution scheme. This is one of the very limited schemes that are available from an employer-employee contribution perspective, available to the organized sector. What it does is at the end of our retirement period or upon death or for limited purposes where an advance is required, the accumulated balance along with interest, and the interest is a very reasonable rate which is constantly provided by the authorities, which is credited on a cumulative basis month on month. And this corpus acts as a reasonable amount for us when we say that this is the end, this is I'm going to change course and then call it as retirement and so on, that is when this lump sum is available to us. The advantage, of course, is that there are significant amount of tax benefits to it, and the kind of assured return one gets on this, well, I would call it assured as loosely worded, but since it is a regulated rate of interest, no, it is more or less kind of seen as an assured return. There is one part to the Provident Fund contributions. The employer contribution is partly diverted to the pension scheme. And unlike the PF scheme, which is a defined contribution, the pension scheme is a defined benefit, because the pension that one gets is based on the average of last 60 months' wages. To be eligible for the pension, there is a mandate that 10 years of contributions are required. If the 10-year contribution criteria is not met, then a withdrawal benefit, a lump sum withdrawal in accordance with Table D of the pension scheme is available. What is also available under the PF scheme is the employee deposit linked insurance scheme, which is based on a contribution made by the employer. There are some exemptions which some organizations which take an exemption from the EDLI because they may have a better scheme. But what this scheme essentially provides is a death benefit. Upon death of the employee, there is a benefit which is provided, which ranges between 2.5 to 7 lakhs. The benefit is based on the wage, which is the last 12 months wages. And there is a lump sum also which is added to it. And this benefit is available where the contribution is made at least for a period of 12 months. While this is a good benefit to have, I do see when employees move from, say, an organization which is exempt to the RPFC, there could be a challenge because when they are working with the exempt organization, they may not have made payment of the EDLI, and once they come into the RPFC, unless they contribute for 12 months, they may end to lose this benefit. So this is something that we see on the ground. So I thought I'll call out. This is a very good benefit that is available to the employees. Now going forward, so how does all this pan out in terms of our compliances? So Preeti, if we could go to the next slide. The Employee PF and the pension scheme is covered by the Provident Fund and Miscellaneous Provisions Act, and there are two schemes under it, which is the PF scheme and the pension scheme. As per the provisions of the scheme, all establishments which have 20 or more employees are covered. And it's also possible that I may not have 20 employees, but I would want to take a voluntary coverage. That's also possible. There is this concept of statutory wage ceiling, which is 15,000, and employees earning more than the statutory wage ceiling can be treated as excluded employees. But the PF provisions under para 26(6) also state that though I'm earning more than the statutory wage ceiling, an employee could opt in to be covered under the provisions of the Provident Fund Act, and there is a procedure to be followed for it, and the employer has to confirm that the employer is willing to pay the administration charges based on the higher wages which the employee is earning. In practice, most organizations do not limit the PF contribution on the wages of 15,000. They make the payment on the statute, on the basic salary, which in most cases may be higher than 15,000. From a pension perspective, a part of the carve out of the employer contribution is carved out towards a pension, and EPS members from 1st September 2014, those earning more than 15,000, and if they are new members, so if they've been existing pension contributors, then they continue to contribute to EPS even if they change employment. But if they are a new member after 1st September 2014 and earning more than 15,000 per month, the coverage under EPS is not available. Now the question comes, who is an employee? If an establishment is covered, who is an employee who is covered? So any person employed for wages, and it would be in connection with, and it is important to note the word in connection with the work of the establishment, and they receive wages directly or indirectly. So a cross charge of cost could be considered as indirect wages, and hence the person would be considered as an employee if the employer bears the cost, and the person can be employed either by the establishment or through a contractor. So even for contract employees, there are applicable, these provisions are applicable. So it's important for us as employers to make sure that contract employee compliances are also looked at carefully. Apprentices under the Apprenticeship Act are excluded. Exempted establishment, there is this concept of exempted establishment. If an organization maintains the PF trust and they provide benefits which are either more or on par with the EPF, then they can seek for an exemption, which means that the monthly PF contributions do not go to the RPFC. They are pooled into the trust, and the trust is subject to guidelines in terms of investment regulations and so on. They need to provide either the same rate of interest or better rate of interest to the members, and they would be subject to annual inspections. There are requirements in terms of maintenance of records, subjecting them to audit and so on. But broadly, the fund is maintained with the PF trust. Now, let us look at what are the compliances to be looked at. And in this case, I'm looking at compliances from a domestic worker perspective. I talked about the statutory wage ceiling of 15,000. 12% of wages, which can be limited to 15,000, is to be remitted to the Provident by the employer, and 8.33% of this is diverted to the pension fund in case a person is a pension fund member prior to 1st September 2014. After 1st September 2014, as I mentioned, if the wage is more than 15,000, the diversion to pension fund does not occur. The entire amount is remitted to the PF account. And this, along with a matching contribution by the employee, that is 12% of wages, the amount has to be remitted to the RPFC or to the PF trust, as the case may be, within 15th of the subsequent month. In addition to this, there is an administration charge that is required to be paid at 0.5% of wage by the employer. EDLI payments of 0.5% of wages, again limited to 15,000. So unlike the PF administration charges, the EDLI payments are limited to 15,000 in basis of 15,000. If it is a PF trust, that is an exempt establishment, inspection charges will come in instead of the PF admin charges. 0.18% has to be paid as admin charges to the RPFC. Now the big question is, what is pay for the purpose of PF? There is a clear definition, and this includes basic salary and earner's allowance. It excludes HRA, bonus, overtime, commission, or any other allowance of a similar nature. And there was a big debate about what is any other allowance of a similar nature. And in February 2019, the Supreme Court came out with a ruling in the case of Vivekananda Vidya Mandir and others, and concluded that any payment which is made by the employer as wages, which is uniformly, necessarily, and ordinarily paid to employees, is required to be considered as wages. And this brought a big topic to, this settled a big topic which was under dispute. And broadly, organizations where they are paying employees more than 15,000, the PF contribution is made at least on 15,000, unless the actual wages is lower, meaning if there is only a basic salary, which is say 12,000, and there is an HRA of 3,000 or so, employers may contribute on 12,000, but otherwise all other components would be included and PF would be paid on that. In respect of employees with wages more than 15,000, of course, it depends on the choice of the employee typically. But at least a PF should be contributed on 15,000. Now, while this is broadly the compliance, there are many procedural aspects which would need to be looked at by organization. While all of us are aware of this, I would just touch upon some of this because some of these could come in for discussions. So employer needs to look at, make sure that the UAN is generated, because the UAN is the identity from a PF perspective. KYC and linking with Aadhaar. Linking with Aadhaar is mandatory because that is what ensures the uniqueness of the PF account. The monthly filing of the electronic remittance challan. So, and this is possible only if the Aadhaar linking has happened. From a procedural perspective, it is important for organizations to make sure that the right information is obtained from the employee at the time of onboarding. Traditionally, this is the Form 11. Citizenship, for instance, is it the employee a first-time member? And this is important because if the employee is already a member, then the employee cannot opt out of PF. So it is important to get that. Similarly, has the employee already been a pension scheme member? So these are information which are mandatorily required to be obtained at the time of onboarding. It is also important to obtain the citizenship details of the employee, and I will come to the next slide when I talk about that. The other information which one needs to look at is the nomination details, which is now electronically mandated. Now coming to international worker, while we talked about domestic worker and we talked about the statutory wage ceiling, the biggest difference from an international worker perspective is the fact that anybody who's holding a non-Indian passport. So we need not go too much worried about how do I determine whether a person is international worker or not. It is simple. Look at what is the passport the person is holding. If it is not an Indian passport, then the person becomes an international worker. It includes OCI card holders. Again, I'm reiterating because typically OCI card holders do not hold Indian passports. And in such cases, the employer is required to file a form IW1, which declares what is the nationality of the individual, call out what is the wage. And here we need to be more mindful because the statutory wage ceiling of 15,000 is not applicable. And hence it is important for organizations to determine what is wage. And the principles which came out in the case of Vivekananda Vidya Mandir and others are very, very important. And clearly all components of wages except those which are specifically excluded like HRA, bonus, overtime, all other components are required to be subject to Provident Fund. And clearly in this case, if the person is an international worker and has been contributing to PF prior to 1st September 2014, the employer contribution will include both PF and Provident and pension scheme, and 8.33% of the total wages needs to be diverted to pension. Only 3.67% of the employer contribution will go to PF, and the employee contribution of 12% will also go to PF. There are restrictions. What makes it different is that for a foreign national who is not covered under what we call as a social security agreement, the withdrawal is permissible only at the age of 58 upon retirement. And the credit of the PF withdrawal has to happen to a bank account in India. So the person has to keep the bank account alive till such time. Further, pension benefits also for somebody who's not from a non-social security agreement country is available only if contributions are made for 10 years. Otherwise, there is no benefit. The withdrawal of contribution benefit is not available for foreign nationals. The provisions are different if the person is from a country with which India has signed a social security agreement. It is possible for such employees who are foreign nationals covered under a social security agreement to have a withdrawal of Provident Fund when they repatriate from India. Similarly, in determining pension, we have a provision which is called totalization. So they need not necessarily contribute to Indian social security for 10 years if their overall contributory period, including period of contributions made to the country which is covered under the social security agreement, exceeds 10 years, then we have what is called as a totalization benefit and the person would be eligible for pension. Now, a slight deviation. While people who are deputed from India to an overseas country may not be international workers, quote unquote, because they hold an Indian passport and they may continue to contribute to Indian social security, or they may not contribute to the overseas social security regime, some nuances are to be kept in mind for such employees. Typically, the social security agreements provide that if I contribute to Indian social security while I am deputed to an overseas country with which India has got a social security agreement, there are certain conditions which are prescribed, which including continuing contributions to Indian PF, which would make me eligible for a certificate of coverage. Once I hold a certificate of coverage, I need not pay social security contributions in the overseas locations. But I would call out a caveat here. It is important to understand which are the eligible pillars of social security regime in the overseas country. For instance, Belgium, it's got about 38% social security cost. All of that is covered. But in France, there are only certain pillars which are covered under the social security agreement. So those which are not covered, the contributions would need to continue. So it's important not to blindly stop the overseas social security contributions just because one has a certificate of coverage. Similarly, for a person coming to India also from a country with which India has got a social security agreement, if there is a certificate of coverage, then there is no contribution required in India. And it's important to make sure that the certificate of coverage is a valid certificate of coverage. Coming back to the outbound, employees deputed to non-SSA countries, there is no requirement to contribute to India PF if no salary is paid or payable in by the Indian entity. Because in this case, there is anyway no certificate of coverage possible. So companies may choose to stop the India Social Security contribution. But again, they need to be mindful. There is a circular which is being issued by the PF authorities to make sure that if there is a salary paid or payable in India, then PF is required to be continued. But the question arises, if there is a payroll shift and I'm not paying salary in India, can I continue PF contribution? Is it mandatory to stop PF contribution? From an employee perspective, if PF contributions are not made, no, it could impact, of course, the interest. It could impact the pension benefit they get because no, there is no contributory period. How do I disclose it if I continue, say, gratuity benefits, but if I am not contributing PF, how would it impact the employee? And in any case, if the person is going to a social security agreement country, and if it's a payroll transfer that there is no PF in India, of course, the detachment benefit cannot be waived. Now, let me just move over and quickly cover what are the consequences of, if I can go to the next slide, what are the consequences of non-compliance? Of course, interest, if there is a delay or there is a default in payment of PF contributions, simple interest at the rate of 12% is payable. This is a mandatory levy because the EPFO has to pay interest to the employees on a backdated period. So if there is a delay or default, the employer has to pay the interest to the EPFO. Damages, in a situation where there is a default, there is a levy of damage that gets triggered, and this will be as per the chart. The maximum levy of damage will be restricted to 100% of the amount in arrears, but it would be in a sliding scale, as you can see on the screen. The commissioners have the authority to determine the applicability of PF or determine any amount which has been in default under an inquiry under Section 7A. The employee establishment will be given an opportunity of being heard before an order is passed. And if in case the establishment is not happy with the outcome under 7A, an appeal may be filed. There is a time limit. There are typically about 70% of the payment, 75% of the payment would need to be, demand would need to be paid before going on appeal unless a stay is obtained and so on. So this would need to be followed. Now, I would quickly like to go to the last slide in terms of what are the topical conversations which we are hearing from the industry. In the recent past, there was the Supreme Court ruling which enabled employees to choose to contribute on higher pension. So the ask was, if I have been contributing to PF at a higher amount and not limiting my contributions to the statutory wage ceiling, then and this is prior to 1st September 2014, I have an opportunity to contribute to higher pension. And there was a procedure which was laid down. The employee has to make an option. The employer has to approve that. And then there has the RPFC has to approve. This would involve a significant move of funds from the PF account to the pension account. But it would enable the employees to, or the pensioners to have a higher pension. So this is one question which is, there is a lot of discussion around this in terms of how do I made this application? What next? Are there questions being raised by the RPFC? What happens? How do I certify if there are periods where in the past I do not have complete data, but I know that I have not limited my contributions to 15,000 or the statutory wage ceiling in the past? How do I demonstrate to the authorities? Say one of my past employers is no longer there, but I know I have my PF details. How do I establish the employer confirmation? So there are a lot of questions around this. So this I thought was one of the topical issue. Sir, may I go and cover all of this and then open it up? Are you okay for that?
I think that will be a little delayed, Saraswathi. We already crossed the hard stop timeline, so we need to give him time. But let's stop here and maybe give him time. We can have a read through on the entire thing, whatever.
Sure, we'll do that.
We can put the screen live so that we can keep addressing that as well.
Certainly. So I'll just keep this. So maybe we can go through this, sir. Is that okay? Or would you want to set the context separately?
You have covered everything to set a context.
Let this slide be on as such, and then we start the conversation, and maybe we can, as we go along, we can always fix it up. Yeah, go ahead, sir. Thank you very much. Thank you, Saraswathi.
Sir, thank you. Thank you.
Thank you, Saraswathi, for setting the context from employees' perspective. And you beautifully touched certain points. So let me start with compliance. Compliance, especially 3-4 things we have observed by even big companies. Actually, they may not have the intention to default in any way, but I think certain industry practices have come into pass. One is this joining month contributions as well as exit month contributions, especially when payroll cycle is different from the calendar months. That we have found in many companies. Many companies after our, they came, some claims have been rejected, then they came for discussion, then accepted, and without any notice or something, they started making interest in penal damages. The issue is that, let us say that somebody joined on January 27. Employer will declare the date of joining as January 27, but since the payroll cycle is 25th to 24th, that 4 or 5 days wages will be calculated and will be paid along with February salary. PF dues also will be paid along with February and in the name of February wage months, okay, payable by 15th March. But that is not as per the law, because as per the law, once wages are earned, PF is paid. Whether wages are paid or not, that is a different matter. Authority is different. But once wages are earned, PF is payable. And since month is not specifically defined in the act or scheme, we should take only calendar months. Month cannot be modified in any other way. So that is one mistake employees are usually, many employees have made. One of the first employer who accepted the mistake is one of the global consulting or auditing company. And they have done the mistake for more than 6,000 employees. So similarly, and this full and final settlement is much more common in the industry. Until the assets are returned by the employees, companies will not close that payroll. They will release the last 1 or 2 months wages as and when that is returned. It may take maybe 1 month or 2 months, sometimes few months also. So EPF also they will generally pay whenever they pay the salary arrears. In the, let us take an example of July, employee has exited and his wages are paid in September or October. EPF also will be paid against the September or October as a wage month. But it should be paid against July as a wage month because he worked and earned salary in July. That is much more common. That was also found out in many companies. Now they have accepted. Once we have a discussion, without any notice, many companies have accepted. So this, what we are solving it, how we are solving it. Let us say July dues are paid in September or August, September or October, then that is a delayed payment. If you change the wage months to July, then you have made the payment after 2 months or 3 months. So that will be taken as a delayed payment, then applicable interest and the damages will be demanded. So that is how they themselves arrived, like that particular company for 6,100 members, they themselves arrived at what is the amount due under section 70 or under section 14B. They simply remitted around 8 lakh rupees. For an individual case, it is a small amount. It may be some 20 rupees, 30 rupees, 50 rupees, but together it comes so much. That is the compliance part. And so whether member will earn the interest, that question will naturally come because member is due for that interest. So we are adding that, whatever the shortfall through our own internal mechanism. That is what I've been doing in my office. Most probably we are the only office who are taking that action and giving that interest also for that. That is one issue. The second, what we have found in a good number of companies is employees contributing voluntarily on higher wages beyond the ceiling, statutory ceiling. But company employer is restricting to ceiling. There is no issue. What employers are committing the mistake is that they will declare the EPF wages as 15,000 and remit the employees' contribution on higher than 12% of 15,000, or even sometimes we are seeing that 40,000, 50,000, 1 lakh, even 2 lakh will be paid, but wages will be 15,000. Their explanation is that, sir, employees contributing only on 15,000, so we declared the wages as 15,000. I have remitted. Even today, just before coming here, I approved a claim of a director of a company whose account was impacted like this. Incidentally, last week I visited the company. So there also, we kept the claim till that employer remitted the sought administrative charges. For 10 years, they have committed the mistake for that particular employee. Sought administrative charges alone came around almost 1 lakh for one employee. Okay. The question was there, why this office is only taking action? And I explained, industry practice is not law. Somebody started some wrong practice, somehow it has got established. But law says very clearly. And that is where, as Saraswathi pointed out, para 26.6, submitting joint requests for contributing or joint requests for seeking permission to contribute on voluntary particular software is allowing or not allowing, that is a different matter. So that is a second most important issue. In case that employer refuses to pay, no, I will not pay the administrative charges on higher wages. What is the implication? In the absence of joint request under para 26.6, that particular contribution will be treated as erroneous contribution. That particular contribution is remitted in respect of an member. The example case is a 10 years contribution. It will be taken as erroneous contribution. It is not an EPF contribution. We will return the same amount to the employer last 10 years without any interest. Okay, so that is a big loss to the employee member. Right? He has kept the money with EPFO. They are not even earning any interest on that. Right? So that is the implication. So submitting joint request under para 26.6 circular has been issued in January 2024. But circular says that don't insist. It has been, EPFO officers have been directed, don't immediately insist till the digital version is coming. But there is a practical or there is a legal implication. If the money is, let me make it very clear. As an employer, employers are permitted to deduct maximum of 1,800 from the salary of employee. That is what Act permits, law permits. You cannot deduct 1,801, right? You have no legal authority. The legal authority comes when you give a joint request under para 26.6 to the regional commissioner and it is received and accepted not below Ascent Provident Fund Commissioner. Then employers have the authority to deduct that voluntary contributions. Okay. So without that authority, if an employer deducts the amount and defaulted in making payment to EPFO, I have no authority to come and take any action against any employer. Because that is not an EPF due as per the IPF Act. So that is a serious implications for the member who is contributing. Okay. People think that, why are you asking paper-based return? Okay. It is there, the act and scheme. So, why it was brought into the, and that was the most important provision based on which the Supreme Court passed that ruling in November 2020. So that is the implication. We may not be insisting, but that is the most important. So I would advise all the employers start submitting those forms because that gives you legal protection both ways. 26.6. So now that the form has been officially notified, it was not there. People used to design their own forms. Now it has been officially notified. So please use it. We are not forcing that everybody should come. At least you start doing it as whenever employees are joining, and if companies have the practice of contributing on full basic without any restrictions, as part of the onboarding exercise, please give the form, get it signed, make it very clear what is the wages, so that there is no confusion, there is no action after 10 years. Start administrative charges is only one thing. Then subsequently interest penalty demand will come. Okay, 99,000 is not the. It will come. It may become 2 lakh to 2.5 lakh also. Okay, that is just for one employee. If you are going to check all other employees, it may increase also.
So you could take a city like Bangalore. I think there will be hundreds of employees, sir, on the same line, isn't it?
Let me put into context. My office is almost receiving 10,000 crore in a financial year. 10,000 crore includes contributions and administrative charges. Okay, and this is the last financial year figure. We're almost touching 10,000 crore. And kind of 7,000 crore is voluntary contributions. 7,000 crore.
I mean, if you equate this.
My office alone, I'm telling about my office, we have 8 regional offices in Bangalore city. And Bangalore city, Bangalore zone, which is the biggest zone in EPFO, out of 21 zones. Bangalore zone has 8 offices in city and Tumkur also. It collects 20% of the contributions and administrative charges. So Bangalore zone and Bangalore city has a special place because 1/5 of the money is being collected from the companies registered here. We have, this city alone has 8 regional offices. That is the highest number of regional offices any city has in India. And there, in another maybe few months, 2 more regional offices are going to be opened in the city. Because it is growing, we are unable to manage within. Because there is a limit for each regional office also. So in that particular context, how voluntary contributions are being collected, remitted, what is the regulations around it? Every employer must know that to avoid nasty surprises at the time of client settlement. Okay, the example case I told, it was a company director. And I went there, he was only actually introducing the company, what it is. Then finally he raised that issue. I didn't know that his claim was impacted, and I only returned that claim because amount was very high. So issue is that industry practice, right? People have failed to read, act, and speak.
Sir, but not only industry practice, across India, people are doing the same thing, isn't it?
We see. Today, in this particular 3:30 to 4:30, 2 meetings were scheduled for me. Okay, all of a sudden, one from my zonal office, another from headquarters. I was part of a committee. So both meetings I had to excuse myself because I already fixed. I have committed myself. So that is how the work is going on actually. So our resources are very limited. Even though we are collecting 20% of the contributions and administrative charges, the HR resources is only 4%. What is available across EPFO, we only have 4% in the Bangalore city. So we are giving 5 times, you can see, our 10% of the clients we are receiving here, 14% of the money we are being paying from this particular city. Okay. That is growing actually. So we may be reaching 15% also. So voluntary contribution is the most important thing because I know that many of the companies covered under Bangalore, they start with voluntary enrollment as well as voluntary contribution.
Both. Yeah.
Both. So para 26(6) is most important form or declaration apart from form 11. Form 11 is sacrosanct.
Yeah.
Okay. Like your employer's form 5A. Form 11 for an employee is most important. Every single line they should know before not
signing
marking, because the practice I'm seeing that. Are you a EPF member? Yes. Are you a EPS member? No. As if that it has to be like this. Yes, no, yes, no. I've seen many such formula. Because that is one of the issues, topical issues attached here. We know that is one of the big reasons causing client rejections also. The confusions related to EPS membership. So I touched upon 2-3 points. Then EPS members. See, the law is very simple. Adam has pointed out very simple language actually. The reason is that since we are not insisting para 26, the joint request under para 26 for voluntary enrollment, everybody has forgotten. So now, if you ask which is compulsory enrollment, which is voluntary enrollment, many companies will come. Then no, everybody is compulsorily enrolled. Yeah. That is a policy of the company actually. We will cover everybody under EPF, but that is not the law. Law says that when you are earning 15,000 or less as a pay, it is compulsory. When it is more than 15,000, scheme says excluded employee. So those employees are also allowed to be enrolled, but through voluntary provisions. That is where para 26 joint request form is. So if you introduce that form, then the clarity will come. Those who are joining voluntarily into EPF after 1st September 2014, they are not entitled for pension scheme membership. Very simple. Those who are already member of EPS on that particular day and continues that membership without closing that and by transferring the accounts, then they will continue to be pension scheme members. That is the most two important distinctions. And since people are moving companies after companies, the same member account, some companies would have enrolled him into EPS, some companies would have excluded from EPS. Okay, so that is a daily issue we are facing actually. And the employees, it is very difficult to deal with that. Employees also, I cannot find fault with employees also because they don't have clarity that whether particular individual is a EPS member or not, unless his whole records are verified. That I think as a policy, some companies may not ask, or some companies may not have access to that. That is where declaration is becoming important, but employees are making declaration without full knowledge. That is another issue. Personally, I have been raising this issue for 3-4 years with my organization to have very clear provisions in the portal to mark a particular UN whether he is a EPS or a non-EPS. That would make a much better thing. We need to wait for that. Till that time, it is work is manual.
Because as employers, we get the UA not available or UA number saying you know EPS. We go through, then we discover that.
So the practical advice would be ask the individual to verify the passbook of his previous accounts. When his membership started. When his membership started is the most important question. Whether he continues the membership. And then these are the two important things based on which you have to decide. Because previous employers might have decided wrongly also. Just because previous employer has made a wrong decision, you need not continue that. Because that will accumulate the problem also. Just morning I checked a mail from one member, or I think somebody came into my LinkedIn profile. I keep it open for members to come and raise issues across India. The issue was same. Infosys is joined. Infosys wrongly remitted to EPS, and subsequently he moved to all big companies, PwC, Deloitte, Wells Fargo. And only Wells Fargo has done the right thing. Okay, so now it's becoming much more complex because Infosys is an exempted establishment. They already transferred the EPF part to this company, but EPS part, how to deal with that? There is no clarity. So that is where, as an individual member, it is much difficult for him. There are different advisors. Officers also take different stands. So try to avoid these mistakes. When you are confused, when you are not clear as an employer, communicate with your RPFC with facts and get a formal advice. That is always my advice. Don't ever try to get a oral advice. No. Send a mail, or you are permitted to raise grievance through EPF IGMS portal also, so that there will be a record of your questions or queries and get a time-bound reply, and they are actually bound by the truth. There cannot be any wrong reply. If wrong reply is given, then employer cannot be penalized for that. So that is my sincere advice. And this is actually, this is where your compliance should start within 48 to 72 hours of somebody joins your organization. Don't wait for the due month to start. Then try to rush it. You will have limited time, then naturally there will be delayed response from RPFCs. Then your due date is over, then you will be penalized for that. You can't help it. So it's always better to raise those important queries where enough days are available to get the replies. Since the portal is being run for 24/7, you can generate EUN, register EUN at any time. So raise these questions in advance. And related to that, EUN generation as well as EUN registration, because these are all related. This is where the third question, inaccurate information relating to past pension contribution. Okay, let me touch that. Once a company has committed this mistake, or multiple companies have committed the mistake in a particular member account, how to do that? And the accounts getting transferred to latest account. Here, once the let us say 2 or 3 accounts are transferred to the 4th account, and the previous accounts are all have been closed, then the current PF office can only do the corrections or adjustments, whether it is EPS or non-EPS member. And respective employers have to submit the Form 3A, because that is the monthly statutory return based on which corrections can be done. RPFC on his own has no authority to do any corrections. Corrections can only be done based on the statutory return filed by employers or through dues determined under Section 7. Administratively, I have no authority to do any corrections on my own. Okay, so that is where Form 3A is most important. So once multiple companies are involved, multiple companies have to give the Form 3A, but corrections will be carried out by the present office, because all amount has already got transferred to the present account. This is where generally, questions are being raised or confusions are there. And if EPS service is wrongly credited to all the accounts, we have no provision to delete those EPS services also. Those circumstances, respective RPFCs have to certify that a particular member is a non-EPS member. Then based on that, I will give a request to my IT team. They will do the deletion through backend intervention. Okay.
The NDC.
Yes.
Yeah.
Even today, just 1 hour before, I have signed a letter. Okay. So that is how maybe in the new software there may be a much more clear process available and all. But we are solving. No question of leaving anything to chance or as it is. We are solving the issues. But employers can avoid this. If you spend little more time, employers can avoid this situation. The second point, interest penalties on account of Aadhaar non-CD. This is, yes, this is now every employer is facing this. See, there are two situations. One is a person has been taken on employment where he has no previous EPF accounts. He's a first timer, but portal is not allowing to generate EUN because of some mismatches. Okay, then maybe like general issue maybe his Aadhaar has only year of birth, but you have to enter the date of birth. Simple solution would be that if a member tries to download the e-Aadhaar, mostly he will get the date of birth, because based on my experiences for the last 7 years, Aadhaar authority always entered some date of birth actually. They might have printed only year of birth in the card, but in the record, date of birth is available. So once the member tries to download e-Aadhaar, definitely he will get the full date of birth. So very rare occasions like 1 or 2% cases where record itself has no date of birth. Then he has to go to the UIDA and get it changed. There is no alternative. But if you already employed that particular person, then you need to write to RPFC. This is the factual situation. What would be the advice of the RPFC for ensuring timely compliance? Because portal will not allow UAN generation. You will not be allowed to make payment through ECI. And RPFCs are not empowered to accept payment other than electronic payments. I have no authority to accept. Authority lies with Central PAPF Council.
No DDs can be given.
Yes. Other than net banking payment, I have no authority to accept it. Okay. So this is where here also written communication is most important. This will create a record for the employer that they within the time they have already communicated to RPFCs. Then second situation would be an employee joined with existing UAN, but the details are not correct. So what can be done in that particular situation? If you have not taken that person into employment, then you can advise that individual go to the previous employer, submit that joint declaration form for correction and get everything corrected. Then allow him to join your company.
Okay. That's a long process.
No, that is one option actually. If you have that kind of flexibility available. We don't have that flexibility, as you say that the companies say that that skill is most important.
Yeah,
we
don't think of all those things.
No, people are now complaining that they are losing jobs. Employers are not taking, not issuing up.
This is an obsolete story.
So the second choice would be, okay, register that UAN with the existing wrong details because portal will not allow you to edit. Okay, but you register, you start making complaints so that there is no default. But advise that employee to go and same process. He has to go and get it corrected to the previous company. Now he has 2 accounts with the wrong details. Okay. So you have to also submit another joint declaration for your own account also.
Yeah.
And it cannot be done simultaneously because our portal will accept only one request for one UA. But it has to be done. Whether it takes 1 month or 2 months, it has to be done. But when you make this request immediately after registration, we will say that we will see that okay, it's a very genuine request, right? But if you delay for years together, at the time of the registration itself, it is not matching with Form 11. But if you give the joint declaration request after 4 years, 5 years, I will have a doubt, my own doubt, right? So I will take ask for additional documents, ask for proof. All these things will happen actually. I have 1,500 requests in my login. Okay. It's pending sometimes for years also. Reason is that employers are unable to satisfy with the records or delaying there. Okay. So now online JD.
One question there, sir. If it is a new joinee, then can we include the membership only after the person is submitted? See, because if the person is earning more than 15,000 and is a new joinee, can I say that I will include you as a PF member once this is aligned? I'm only trying to see the interest and the penalty aspect. Just one thought.
See, as a EPF commissioner, I would not advise you to delay the enrollment, even though legally you are allowed to do that. Like for voluntary enrollment, you can delay. Because voluntary enrollment, it is a choice of the employee and employer to choose a date. It need not be the actual date of joining. It can be in future date also. But that particular person will not be covered under the benefits.
Pension scheme will be
pension, okay, he will not be entitled. EDLA. With companies, even for exempt EDLA exempt companies also, the coverage will not be there. Okay, so. In my office, I would say that if you promptly submit that request in time, where enough time is available before the due date is over, we will be able to help it. Even for other offices also, if the employee is able to file that request in quick time, then you can use the grievance portals available to push it for quicker approvals. Right? Now the EPF, IGMS as well as CP grams, both the portals are available for filing grievances. Our days for resolving those grievances are very tightly monitored, like 7 to 15 days. Even tomorrow there will be a review. Ministry will take review every second week actually. and now quality of disposals, everything is being monitored actually. So for an employer as well as employee, many channels are available. Sometimes it may take time, I would accept that. But if you persist, definitely resolutions are coming, even for most complex issues also, involving multiple offices also. So that is where your enrollment process should start within 48 to 72 hours from the person joining. Don't delay it to the next month. That is a due month. This is most important for those companies who are outsourcing the payroll, outsourcing the EPF compliance and all. They should take it this, because for us, employer is employer. We don't know whether you are doing your own compliance or you are doing through the second vendor or all these things, your own choice, but the liability will be on you. Okay. Our data sharing, sir, we will not be getting data. Our problem is completely within the domain of the employer. For us, employer means only one entity. Yes.
It's like Indian Airlines.
However big it may be, whether it is a TCS with 3 lakhs or Coast Guard with 5 lakhs, it's a single entity. Then change in pay for PF purpose from 15,000 to higher amount and vice versa. That's where para 26.6 comes. See, we used to take very practical view with reference to the staff Provident Fund, it is kind of a freely, employees are deciding actually. We never intervened actually. Employees used to start contributing on a voluntary basis. After some time, they will go back to the ceiling. Both the things are happening. But it is not made it very clear in writing that what is the position actually. Whether it is one way, that is once you start contributing on higher wages, it is permanently fixed. It is not very clear, so I cannot comment on that. Now, practically, we are not questioning the changes actually. Even within a year, some employees have stopped contributing, gone back to the ceiling. Then after some months, they again started contributing to higher wages. We are not questioned actually. Yes. Then surrender, cancellation, and grant of exemption. Yes, it's a big issue actually. Different. There is no now timeline have been clearly fixed because recently manual has been issued, SOP has been issued, the title timeline has been given, but because of the confusion and all, it is taking time. But last September, October, we have allowed one particular Mercedes-Benz to surrender it. They became unexempted on 1st October. We credited the past accumulations on November 10th. That was the quickest time. Fastest. Even they were expecting 3 to 6 months, but we did it actually. There was almost zero complaint from the company.
It's because it's Mercedes-Benz.
No, we learned our things by handling team leases to all these exemption surrenders. So many things what we have done after transfer of past accumulations, we made it as a proprietary activity. So they have been given very clear steps before transferring the money, so that everything was planned and we were able to do that. Actually. Now we are confident that within 30 days we will be doing it in companies. Transfer of balances on change of jobs, exempt entity to, yes. Exempt entity, I believe that it is like EPF exempted like TCS, Infosys, Wipro, or banks which are outside EPF like.
No, PF trusts we are talking about, sir. Trusts to RPFC, if they are moving, it's not as seamless as RPFC to RPFC.
PF amount transfer now that is happening much more better, I think, last 3-4 years, because a portal has a facility to transfer the money directly from trust to the account with the RPFC. Actually, that is where automatic credit also happening. Those individuals are much more lucky, I would say that, because
But
direct credit is happening and they will have Annexure K also in the portal.
Sir, but earlier when RPFCs were giving this, there used to be instruments and instrument transfer used to happen also that part of it. Now cash is coming in, you don't get yields for that issue. Where do you go for that?
That is a past, okay. Past issues are also there. Now one by one we are solving. And from RPFC to exempted trust also now anyway we are electronic transfers. But Annexure Ks are not being issued to the members. But Annexure K is available to the exempted establishment portal actually. They have the, I think, 7-8 year history is available in their portal. I would say that they are not checking. Many of the companies are not checking. 3-4 facilities available in the exempted establishment login to check based on different parameters actually. Because that is one of the preparatory activity we always do for before surrender. But that creates a lot of problems for us actually. PF contributions on hold during overseas deputation. That depends on the facts. You already tabulated different categories actually. So when there is a clear communication in advance to the RPFC, I think most of the issues will get solved. Only when it is company decided on its own way and it is found after some time, then issues will come up. So when it comes to IW withdrawal, absence of Aadhaar, see section 142 of the Social Security Code, which is already implemented, mandates that EPF member has to be identified through Aadhaar. So there is no exception actually. We used to accept physical claims without Aadhaar, but now we stopped that. Because when we are demanding for Indian nationals, we cannot have a different rules. COC renewals beyond stipulated detachment period is absolutely with the host country. But practically we are seeing that they are actually questioning many such need for employment or extension. So they are delaying the giving consent. So we are unable to give any approvals. Many things are pending across many offices. Issues with the host countries. Now countries like Germany and all is not encouraging at all. Related to the recent High Court judgment on IW provisions, I think organization has already issued a press release. I think they will be appealed because it has a much bigger consequences. The scheme itself is a 16-year-old now.
Yeah.
And we are the only office in India. We already started paying a pension also for one international worker. So it has a much bigger consequences. So organization will appeal like all probable. And I think one point has been missed here, but it was touched on another thing, nomination. Nomination is compulsory at the date of joining itself. Para 34 very clearly says that employers should ask the family member details and the nominees, and employee has to declare that forthwith. So no options here. The day of joining the establishment of a covered establishment and getting enrolled into EPF, employee has to give the nomination. Now, much better option is available through e-nomination. So since UN is portable, e-nomination filed in the portal also portable. So that employee need not file again and again whenever he switches jobs. He can, once a particular UN is registered in a particular establishment, that particular e-nomination also will be available for the employer to view. That facilities are already there. But only thing is that for any fresh enrollment, you should ensure that it is filed. Process is very simple, but understanding the family, what is family in EPF, what is family in pension scheme, that is where the crux, issue lies. Okay, and there is a difference in male member, female member family definition, and so EPF. Family for male member is including spouse, dependent parent, children, widow of deceased son and their children. But for female member, husband's dependent parent also included. Okay. But female member is allowed to write to EPF commissioner that I want to exclude my husband and husband's parents from my nomination. It is allowed. A simple letter is allowed. Male members have no such flexibility.
Yeah.
Okay, but and similarly, but if your religion allows or recognize the separation of marriage, separation, that is also accepted as a separation. Okay. And since EPF nomination allows among the family members, you can choose one or more, you can practically exclude if more family members are alive. That is flexibility is available. For as far as pension scheme is concerned, family means spouse and children. So as long as spouse is legally wedded, your spouse will be entitled for your pension account benefit.
What about human relationships?
That is not recognized. No?
Supreme Court.
No, the question comes, you are legally wedded, but you are already initiating a divorce proceedings. It is going on during the proceedings, member dies, the spouse will still get the benefit for you. Because that particular day, she or he was legally wedded.
Legally.
And scheme is not allowing you to exclude the spouse actually. Pension scheme is kind of auto-nominated scheme. Once family is there, it is auto-nomination. You cannot nominate anybody. So that is my most important request. Complete the nomination. Nomination is compulsory. So employers can be prosecuted if nomination was not obtained. This is your duty actually. It's the employer's duty. So then employers are permitted by the law to collect the family member details. So don't get into no, this is a private information. I will not collect.
Yeah.
No. You are legally empowered to collect the family details of the members, and as an employee also, he is legally bound to provide that information. Because this is most important information. In case that employee failed to complete the nomination, based on the employer declarations only, we will generally settle the claims. Okay.
Thank you, sir. Thank you very much for a very detailed.
See, it's not a very global issue, it's a very day-to-day routine issues. What we are facing, in our normal administration of the PF duties, etc.
See, this joint declaration submitted in physical form, there are a lot of issues. One of the main issues that you can't track, like whether my office is entering that request and processing, where it is pending, how long it will take, you can't have any tracking mechanism. That is the reason online JD has been introduced.
But online is
But that solves only part of the problem. Unless member has access to the portal, he can't file a joint line. The second part is that those members who have no access to the portal, like his UN is not linked to the other, or he has no UN for his older PF accounts. Okay, those things, another provision is going to come. Now that is being highlighted actually. The EPFO has acknowledged that issue. They are going to soon come up with a online mechanism where employer will be allowed to initiate that process. Okay, but till that time, wherever
no access at all, employer has no access.
No, it will be provided actually.
Not yet, but it will be coming.
In future, it will come maybe in another 1 or 2 months actually. Till that time, we are accepting physical joint declaration form on case by case basis actually. But tracking, it is not available. And we won't give update also. How to get an update? You give a request. After some time, you check in your own portal whether the details have been changed or not. That is a practical way of checking that. Online anyway it is available, but process many feel that it is a little complex, or DAC is not allowed for digital attestation and all. What we have heard from head office is that DAC is not going to be given for online JD. E-sign is going to be the method through which you are going to attest, at least for immediate future. Okay, so it is my advice for all the employers to activate at least one e-sign in one company at least. Okay, there is no escape for
one DAC.
DAC will not be allowed.
Will not be allowed.
Yes. 10 to 15, that is very age-old problem. I have no solution for that. But you try to see the practical way of dealing with this, that you complete the UN generation, UN registration process much in advance. Don't try to do everything in between 10th to 15th.
So the problem is actually in units. we have a cash constraint, that we have to pay the wages.
That is for payment, sir. That is for payment.
I'm talking about payment.
You complete this UN registration generation because that is where portal is overloaded actually. Now, I would not say that it is not such a big problem compared to 2022 or 2021 and all. It's okay.
But it's an electronic issue that should be easily.
It may get solved when new software comes, maybe after a few months. Not in the present software.
So thank you, sir. Thank you for a very detailed note. We will also try to address some of these issues to our members by answering those questions raised and probably circulate. That's something that we can do. At the same time, thank you for elaborate discussion. This is a law which is as old as 1964 Pigeon Rules. There's no change in the Vivekananda Vidya case, but then it's been every day changing. That's the big change that we have here. We look forward to.
So one more actually, I thought of starting with that. The issue is that how to avoid industry practices. Correct. I would suggest that, especially in Bangalore, because we are having now 8 regional offices, another 2 is going to come. So you will have at least 20 to 25 regional commissioners and 1 additional commissioner sitting here. I think the forums like this, BCIC, all should formally coordinate or collaborate with regional peer EPFO to have a kind of some kind of a training for compliance teams. I would say that I have interacted many compliance teams of many different organizations in 2 different cities. Beyond a point, knowledge is seriously lacking. If you don't know, that is much better. But if you are confident that what I am doing is correct, but basically it is wrong, and that is where all these.
Most of us are not experts in theory.
So I think training is needed, and unfortunately, EPFO has no formal mechanism. Even though once in a while they used to conduct some training in ZTAs, that is very, very limited actually. You can collaborate. And you can start those trainings so that regional commissioners or assistant commissioners can be called to speak on certain topics. So this will make more things clear. Actually.
Thank you, sir. Thank you very much for coming for this session. Thus, we enjoyed it thoroughly on behalf of BCIC and all the members here. Yeah, pictures would be better here. Yeah.
Thank you.
Valuable. As I said, ma'am, we deeply are grateful to Ms. Saraswathi for sharing her perspective on industry. It was very enriching to know a lot of topics which industry are facing, a lot of things as if it was like from my mouth, she was able to tell it. I would also like to take a moment to acknowledge the hard work and commitment of the organizing team, the seamless execution of the program today, which is both hybrid session, accommodating both in-person and virtual attendees. I'm sure this program was more informative. Thank you very much and have a wonderful evening. Thank you, ma'am. Thank you, participants.
Thank you. Thank you all. Thank you. Please.
Many queries are coming in.
I think in the chat.
Yes.
Yeah. Collect it and let's also circulate and understand.
It generally takes 2 hours. I will be continuously speaking.
Yeah.
So I will do it actually. So 45 minutes and all is very short time.
In fact, when I told her also.